I got the Allen case shortly after I was appointed. I was appointed in 1978. And the Allen case had some very interesting attorneys. Stuart Udall was one of them. A man named Dale Harrelson was one of them out of Arizona. A man named Wright out of St. George. There were 1,192 plaintiffs in that case, asserting that they had suffered as a result of exposure to low-level radiation because of the testing that had gone on in Yucca Flats, Nevada. And they were suing the United States under what's called the Tort Claims Act. In ancient history, the king, being a servant of God and an appointee of God, could do no wrong. The government, eventually succeeding to the kingship, could still do no wrong. But eventually, the Congress, in their wisdom, when they actually passed legislation, passed the Tort Claims Act that said, in effect, if the government does bad things through negligence, it ought to be as responsible as a private person. And it was under that act that the Allen case was brought. Well, you can't hear 1,192 separate cases, and they weren't a class action, they were separate cases. So we worked out a system where I would have the attorneys jointly select what we called bellwether cases, representative cases, that would be in a position to have evidence of such a nature that we could decide the issues. And once those were decided, deal with the other 1,100 plus cases on an item by item and case by case basis. And we tried that case with these prestigious lawyers, with a few side-in little incidents. The United States wanted me to be specially vetted so that I could be privy to secrets. I'd just been passed on by the United States Senate. I'd just been appointed. I'd been vetted by the FBI. They had checked back to my grade schools in their examination of my alleged fitness. And I brushed that aside and told them we were going to go ahead. Anyway, we ended up with our so-called bellwether cases. And we tried that case for 13 weeks. And we had about 7,000 pages of testimony. And we had almost 2,000 exhibits. And we had the most amazing array of witnesses I'd ever seen up to that point, and indeed since. And it took us more than a year to write that opinion. Very long. Almost a full ream of paper. And of course, the United States took it up on appeal. And the Court of Appeals reversed me, saying it came within the discretionary function on the part of the United States to do what they did in what I thought was a fairly shallow opinion. But the beauty of that case is that the record that we made over those 13 weeks was utilized by Stu Udall and others to educate the Congress. And the Congress finally said the king has a conscience. And there was legislative benefits provided for an expanded group of people who had indeed been exposed to low-level radiation on the part of the United States, not just from what went on at Yucca Flats, but what went on in the uranium mines as well, and in other locations. Right after we filed that opinion here, it was in May of 1984, I got on an airplane. I had been asked by the State Department to go talk to some people, some judges, others over in West Africa. And I went to Nigeria, and I went to Liberia. And the press on that case had reached both of those places. And the lawyers were astonished that a judge had the temerity to call his government to account. They could hardly believe it. And I was almost like a rock star among the members of the bar and the judiciary in both places because of that effort to recognize that the government itself is subject to law. The court system provides an environment where people end up accepting, for the most part, the decisions on matters of great moment, constitutional matters, rights matters, for example. And I think that one thing that distinguishes the court system is the fact that we provide continuity. That is to say, we can reach back and deal with precedent and recognize history and recognize what others have done. And I think we can provide stability if people feel comfortable about vindicating rights in a system where you can do it peacefully, in contrast to exercising arms, let's put it that way. And I think also a system can provide what I like to call integrity. That is to say, the judge in the federal system, judges are appointed for life, and that's for a purpose, and appointed by the president with the advice and consent of the Senate. But they're appointed for life so that they can be insulated from the reach of inappropriate forces. And one of the things that a court can provide is, as I say, what I like to call integrity. It's disinterested. It's not uninterested. It's disinterested. It has no axe to grind. It is the kind of thing where it can, unlike other institutions, can take time to think. One of the problems in public discourse nowadays, in my opinion, is that everybody has an answer in 30 seconds. Everybody pretends to talk about a 1,200-page bill without having ever read it. I tell the kids that work with me and others that have, you know, when all else fails, look at the books. When all else fails, read the documents. When all else fails, know what you're talking about. And I think that in addition to taking time to think, that in a hotly contested legal proceeding, civil or criminal, you're interested in dealing with information and the appropriate gathering of information by the attorneys and the presentation of information. Facts, we call facts. What is a fact? There are 100 variations on that, let me tell you. But we're interested also in the appropriate legal provision applied to the facts. And we end up with juries helping resolve facts. Good system, excellent system. I'm a great fan of juries. They have, I was going to say, good instincts, which I guess is the best I could say. Most juries are conscientious. And most come in before they're seated, before things begin for their benefit, are apprehensive and a little irritated, but when it's all over, they do well. But I'm a fan of juries. I think a broad section of the community, given the opportunity of weighing the information that's presented. Lots of folks think that a contest in court is a battle, a jousting match, theater. At best, I think it's an educational process. When Judge Sirica said to Richard Nixon, turn over the tapes, you probably have the most dramatic example at that point in time that resulted in what subsequently occurred and the resignation and the departure. Calling government to account in the federal system as a practical matter, if you have a moribund Congress, the only remedy that you have is to rap on the third branch's door. And hopefully, if you have standing and if you have an ongoing contest and something that merits the attention, you're then in a position to get a ruling that, believe it or not, in most of our history is acquiesced in by the parties. And you say, why does that happen? Why is it that when we see a third world country or a country in process, that doesn't happen, where they don't pay any attention? In Liberia, Nigeria, some nice judges would get me in a corner and tell me they had issued a writ of habeas corpus directed to the then government, which was military, to produce a prisoner. They've just ignored. Or where somebody who's not part of the ruling party, as happened in Liberia, gets hanged by his heels as a display to teach him a lesson as to acquiesce in what they say. But one of the really interesting things to me is that people are willing, and they're willing because of the process. They trust the process as being a fair process. And they abide even often when they don't even agree with the result, when there is a genuine contention as to differences of opinion. But they abide. And that's one of the interesting things that happens with a case generating on the district level, going to the Court of Appeals, getting in the door at the Supreme Court, and getting a determination. Obviously, nobody's completely happy, but they abide. They abide, and rather than taking up arms or shooting the opposition or engaging in self-help, they, I think, give credence to the process. When we talk about due process which is due, that people are supposed to be entitled to, the American system, difficult though it is, and on occasion flawed though it is, on occasion poorly done, let's put it that way. Whatever. But there's a process. And the process sometimes takes a long time to cure mistakes. Well, you don't leave yourself on the doorstep at home. You are what you are. But you make a great effort to be disinterested, not uninterested, but disinterested. You're interested in hearing the material that's presented and trying to evaluate that as best you can. You're interested in the process that historically has been validated over centuries as to the manner in which disputes can be resolved. You're interested, it seems to me, in taking time to think. You're not there as a partisan, you're there as a judge. And to do the best you can with the tools that you have to arrive at what makes sense. How do you walk away? You don't walk away. You're there. You have your own attitudes. You have your own inclinations. You have your own biases, but you try to set them aside as best you can and assist in bringing order out of chaos and having good reasons for doing whatever it is that you do. When I was chief judge, we were one of 10 pilot courts around the nation, beginning to integrate into the computer world. My own attitude is I love the books. I have trouble with computer screens. I prefer the books. I prefer to be able to handle and look. or to paste or not. But the fact that there is something that's a tool, and that's what it is a tool, and sometimes not a very good tool, in no way should depart from the process of judgment. One of the difficulties with the abundance of modern day technology tools is that people begin to think that they're a substitute for thought. An algorithm is no substitute for thought. Machines don't think. And the process of deciding cases is a human process involving human beings, again, doing the best they can with the tools that they have. And the tools, some people suggest, modify the manner in which we actually look at the material. And I think that's true. I can see in the pleadings that people file the absence of some references that would obviously be there if they had actually gone to the books. Interesting life. I hope we survive.